Welcome to this online lecture. Today, the topic is the European Climate Law, and we will hear a critical assessment whether this law is green enough. The lecture will be delivered by Professor Estelle Brosset, and actually, she's the first speaker from France to this lecture series. We have already had speakers from Italy, Belgium, Cyprus, Scotland, Denmark, Hungary, Germany, and the Netherlands. Estelle Brosset is Professor of Public Law, Professeur du droit public at the Aix-Marseille University in France. Estelle is also co-director of a research center focusing on international and European studies, and important for our lecture is that she is specialized in environmental law. She delivered a contribution to the Research Handbook on EU Environmental Law together with Professor Sandrine Marjan-Dubois. And in that chapter, they focused on the governance approach undertaken by the European Union to address the problem of climate change. Since the publication of that book, important legislative developments have taken place, including the adoption of the European Climate Law. And I'm very happy that Estelle Brosset will provide us with her critical reflections on this important new law.
So, first of all, I would like to thank Marjan Peters and Maastricht University for their invitation. I will try to do my best in English to talk you about greening EU environmental law. What about the European Climate Law? In recent years, greening has become a political buzzword, both within and outside the European Union. The publication of the Green Deal has contributed to this new emphasis of this term. However, like any political slogan, greening gives little or no indication of the status of the law. The aim is to convince, not to describe. So what we intend to do today is to describe what already exists in EU law behind the slogan, and in so doing to bring the light to the relevance of the term if very little exists, or its uselessness if, on contrary, the existing is already important. In other words, in EU law, is greening renamed an already well-established principles and rules, or is it, on the contrary, a new term that reveals blind spots and thus a need for evolution? Answering this question is not easy, and with good reason. The concept of greening, and therefore the question, can be approached in several ways, as we will see in the first part. It's not easy either, because an overall approach does not show details and needs to be completed by a targeted study to check what is actually going on. We will do this by studying the European Climate Law. Indeed, the European Climate Law is one of the founding laws in the new framework of the European Union climate policy. First of all, it's the first legal translation of the Green Deal. Secondly, this translation was intended to be decisive, as evidenced by the name Climate Law. It is therefore interesting to focus on this law. What does this powerful title really mean? What does the law say about greening in its various forms? That's what we will be looking in the second part. Greening will therefore be studied from a general perspective, first part, and then through the example of the European Climate Law, part 2. So, part 1, greening, general approach. There are 3 ways of looking at greening in general context. The first and simplest approach is to use the term to refer to European Union environmental law as such. There is no doubt that this law is specifically intended to impose new obligations on states in terms of environmental protection and thus to green national laws and more generally to green society. This is what might be called greening by European environmental law. There is, however, a second approach which refers to what we might call greening in EU law. In EU law, there is indeed an old principle, the principle of integration, which requires environmental protection requirements to be integrated into the definition and implementation of the Union's policy and activities. Studying greening can therefore lead to a study of the outcome of this principle, which is, in a sense, the translation of the political slogan into law. Finally, and it is the third approach, studying greening and EU law also means looking at the greening of EU law itself in order to analyze if its categories or mechanisms, in short, its rationality, are compatible with ecological concerns. Although there are many different approaches, the conclusion is the same every time. Whether the issue is greening by EU law, in EU law, or of EU law, the ambivalence is strong. In each case, the key word of greening has a legal translation, but this translation is still weak. Greening by EU law, so first. It has to be admitted that greening by EU law has indeed taken place. Environmental protection, although not initially mentioned in the Treaty of Rome, is one of the oldest policies. Well before the first revision of the treaty in 1986, which introduced the environment in the treaty, the Commission and the Council had already decided to do so. You can read it, see it on the screen. Since then, the pace of adoption of legislation has been significant. The current number of laws in this field is remarkable. More than 1,000 regulations and directives, according to the EURLEX database. And the diversity of the issue covered is also very important. Water, air, noise, industrial risk, biodiversity, and climate change. But in order to verify that the greening by this EU environmental law has indeed taken place in fine, it is necessary to question the effectiveness and efficiency of this law. We have to admit that they remain problematic. The Commission's annual reports on monitoring the application of EU law show that. For example, the latest report states that while in 251 the Commission launched only 52 new infringement proceedings against member states relating to the environment, which is not the first place, but 356 are underway in this area, which is in first place. In terms of efficiency, the European Environment Agency's latest report gives many pessimistic indications. Despite some progress, the state of the environment in the European Union remains worrying. A small proportion of protected species and habitat are in favorable state of conservation. The good ecological status of all bodies of water is far from being guaranteed. Air pollution remains high and continues to have an impact on biodiversity, ecosystem, and human health. And the rate of reduction in greenhouse gas emission is currently insufficient. Without going into further detail, it has to be admitted that when we look at greening at this first side, the ambivalence is obvious between a dense existing body of law and a long-standing problematic of effectiveness and efficiency. Greening in European Union law. If you want to understand what greening is in EU law, we immediately come across a principle, the integration principle, which appears in Article 11 of the treaty. This principle has always been part of the policy in the European Union. As you can read, the first action programme had already set the objective. It should also be said that this principle has since acquired a more solemn character. The principle has in fact left the title on the environment to move up to the first part devoted to the principle, general principles. It had also been included in Article 37 of the Charter of Fundamental Rights. You have it on screen. In principle, Article 11 contains legally binding rule. It is enshrined in a treaty. The use of the word must suggests a clear obligation, and the requirement to include goes beyond a simple obligation to consider environmental requirements. However, the generality of the wording of Article 11 and above all the limited usefulness of the principle in litigation seems to argue against it. Of course, the usefulness in litigation is not completely null. Indeed, as you can read, the principle was used as a basis to reinforce the importance of the objective of protecting the environment, in particular as a reason for derogating from freedom. The principle has also been used to settle disputes over the legal basis. The titanium dioxide judgment is the first example. To choose the applicable legal basis, the court refers to the principle of integration and here concludes that a community measure cannot fall into the scope of the environmental policy solely because it pursues environmental protection objectives. Despite this usefulness, even when the principle of integration has been used, it has done nothing on its own. Its use by the courts is always subsidiary, amplifying, accessory. Moreover, no act of the European institution has ever been annulled on that ground. Greening of EU law, it is the third approach here. There is no doubt that certain concepts and definitions useful in the environmental field came from EU law. This is the case, for example, with the concept of environmental liability. This is also the case when EU law defines what is sustainable activity. However, while EU law has often played a structuring role, the most important categories of this law are not very green. For example, there is no recognition in the EU law of a right to a healthy environment. The Charter includes an Article 37 entitled Protection of Environment, but, and it's well known, this article does not confer any subjective individual right. The article only enshrines principles which, moreover, are not new, but on the contrary, already provided for in other provisions of the treaty, Article 191 for the principle of high level of protection and Article 11 for the principle of integration. For that reason, for the time being, this article has not had any effect of its own in terms of litigation. Beyond the substantive categories, greening at the procedural level is no more advanced in EU law. This is the case in terms of access to justice. For 60 years, without any change, in order for a natural or legal person to seek the annulment of a legislative act, it is necessary to prove that she or he is individually affected. However, this is always impossible in environmental matters due to the collective nature of the interests at stake. For example, in the case Carvalho, concerning an action for annulment brought by several individuals against free EU climate legislation, the court ruled that the case was inadmissible. The court acknowledged that the impact of climate change differs from one person to another, but in the court's view, these differences are not sufficient to find that the applicants are individually affected, that is to say, in a manner similar that a person to whom those provisions are addressed. Admittedly, combined with Article 7 of the Charter on the right to respect for private and family life, and in line with the case law of the European Court of Human Rights, Article 37 could perhaps, in the future, lead to the recognition of a general right to protection of the environment. This is what certain advocates general have already said, but this has not yet happened. Certainly, there have been some significant developments in terms of access to justice in the field of the environment, notably thanks to the adoption of the Aarhus regulation in 2006 and thanks to its recent revision in 2021. An internal review procedure is open to NGOs and members of the public. However, the possibility for NGOs and members of the public to access to Luxembourg courts has still not seen any substantial change in interpretation by the court itself. These three angles are interesting, but this is an overall approach. By focusing on one text, a key text adopted for applying the Green Deal, our aim is to see whether or not such ambivalence can be found at a micro level and what elements can be added to the debate. So we can move to the second part of my speak. Greening, a focus on European climate law. From our point of view, European climate law is a clear illustration of the ambivalence identified at a macro level. For many reasons. First, this law is part of and complements a large and long-standing body of law on climate change. At first sight, the European climate law demonstrates that greening is at work. However, the European climate law's shortcomings are numerous, and most of them relate to the effectiveness of the provisions. Greening, therefore, is far from complete. Greening is unfinished. Finally, when we are looking for greening principles in this law, we can't find them. This is another ambivalence of this law. No greening principle. So first, greening at work. It is well known that from the Treaty of Rome to the Treaty on European Union, the EU has developed an environmental policy in which climate change received specific attention since the 90s. The Lisbon Treaty acknowledged this specificity by mentioning climate change among the environmental objectives. One of the objectives is to promoting measures at international levels to deal, in particular, with climate change. The legislation in this area of climate change fit into two main categories. The first category includes instruments incorporating international agreements within EU law, United Nations Convention on Climate Change, its Kyoto Protocol, and later the Paris Agreement. For example, the first instrument in the field of climate change was a decision, you have it on the slide, which clearly related to the UN Convention and to the commitment of the European Committee at the international level. The second category includes instruments that have shaped European internal policy. The adoption of the European Climate Change Programme is the first, even if its objective was also to meet the Kyoto requirements, and following the discussion led after the adoption of the ECCP, the European Parliament and the Council adopted the directive ETS, which was clearly the first step of a long and rich list of instruments adopted since then. These two categories are completed by a third one, which includes all instruments in other sectors that have incorporated the fight against climate change as a general objective. For instance, in the sector of transport, civil protection, protection of the marine environment, or energy efficiency. Thanks to the achievement, the EU had reduced its emission by 23% compared to the 90 levels, exceeding the reduction target it had set itself. But such reductions were not enough to contribute to the targets set out in the Paris Agreement. The EU is not yet on the road to limit the rise to 2 degrees or the more so 1.5 degrees. This is the reason for the Green Deal and for the adoption of the European Climate Law. This law complements the dense existing body of law with a new objective, the objective of climate neutrality within the European Union by 2050. This objective is in the Article 2 of the regulation. You have it on screen. This objective is not completely new. Firstly, it is fully in line with the objectives set out in the Paris Agreement. Secondly, such a target had already been mentioned at political level. For example, in a resolution of the European Parliament in 2090, or similarly, the European Council confirmed this objective in its conclusion of December 2019. But for the first time, the objective of climate neutrality is explicitly mentioned in a binding text. And the mention is much clearer than the mention in the Energy Union regulation. You can read this mention in the recital 10 of the regulation. Indeed, in the European climate law, as you can read in Article 2.2, there is an obligation for the EU and the Member States to take measures to enable this objective of climate neutrality to be achieved collectively. However, if greening is clearly at work with this new objective, a closer look at the details of the law reveals a number of shortcomings and loopholes that show that greening is still incomplete. So, unfinished greening. The shortcomings of the law are primarily linked to the objectives themselves. To achieve climate neutrality, much remains to do, and the next few years will be crucial. In this sense, intermediate targets are fundamental, but on these points, things are not simple. So, first of all, let's recall the discussion over the target for 2030. In its first proposal, the Commission did not set a target. The Commission said it was waiting for the results of a study evaluating two targets, 50 and 50%, before making its decision. This delay was criticized by a number of NGOs as well as several member states. It was only in the amended version of the proposal that the target, 55%, finally appeared. However, the discussion was not finished. The new proposal was debated at the European Council meeting on October 2020 without agreement. The Council only approved the target at its meeting on December. The target was also discussed in the European Parliament, which had initially argued for a 60% reduction before saying yes to 55%. All these discussions have shown that setting intermediate targets is not a simple matter. It should be noted that this is likely to happen again because the law does not set any target between the two deadlines, 2050 and 2030. However, Article 4.3 states that a climate target shall be set for 2040. Even if it's tightly controlled by the regulation, as you can see in the Article 4.5, which states that the Commission shall take into account the following elements, and you can read a long list of elements. So even if it's tightly controlled by the regulation, do that will not be easy. Note that the Commission proposed initially the use of delegated acts for that, but in the end, it was legislative amendments that were favored, creating a higher political risk. Another shortcoming relates to the objectives method itself. Targets have been set, but what can we do if they are not respected? The law confirms the fundamental role of the Commission. A Commission is responsible, you can read it in Article 6.1. Commission is responsible for evaluating progress made by both the Union and the Member States. This is not new, since the Commission has already this role in the regulation of the governance of the Energy Union and climate action. But not new, this method still raises questions. First, evaluation is not a sanction. And on this aspect, the law is very undeveloped. It only states in Article 6.3, it only states that if on the basis of the assessments the Commission finds that the progress is insufficient, it shall take the necessary measure in accordance with the treaties. Added to this is the fact that these targets have been set for the EU as a whole. What the Commission will be assessing is the progress made collectively by the Member States. The EU's climate neutrality does not therefore mean the climate neutrality of each of the members. It is true, however, that provision, especially Article 7, provision is made in a law for monitoring the action taken by each member state to contribute to the common objective on the basis of the information communicated as part of the national energy and climate plans. You can read the Article 7 on screen. The Commission shall assess the consistency of national measures. The Commission shall submit the conclusion of that assessment. The Commission can give to the Member States some recommendations, and the Member States concerned shall, within 6 months of receipt of the recommendation, shall notify the Commission on how it intends to take due account of the recommendation. This is clearly a very important point, this Article 7. But for the time being, it is still too early to say what the outcome will be. On the 18th December, the Commission published its EU-wide assessment. In its assessment, the Commission concluded that the measures are not yet sufficient to reduce greenhouse gas emissions by at least 55% by 2030, since they would only enable a reduction of 51%. On the same date, Commission published recommendations for each country, and the final national plans will have to be submitted by the Member States, taking account this recommendation in June 2024 at the latest. The shortcomings of the law are so important, but they are not the whole story. In addition, and finally, the law is also ambiguous when we are looking for principles relating to the greening. First of all, it should be recalled that nothing is said in the law about the principle of integration. This was also the case in the Green Deal. But the Green Deal set out another principle, the do no harm principle, which states that all EU action and policy should work together to achieve the Green Deal's objectives. To this end, each legislative proposal will include a specific section explaining how this initiative respects the principle. Some have considered that this principle inaugurates a new sequence for the principle of integration. Perhaps. But it should be noted that this principle has not completely spread. For example, in the European climate law, we do not find it as such. Instead, the law refers in the Article 6.2 and 6.4, you have it. The law refers to a principle of coherence, which seems to be another version of the principle. Article 6.4, for example, refers to the consistency assessment. However, in the two cases, principle of doing no harm or principle of coherence, this principle seems to be less developed than the principle of integration. The do no harm principle only concerns proposals linked to the Green Deal. The principles of coherence seems more open-ended. Any legislative proposal is concerned, but it does not seem prescriptive. Coherence is only assessed and non-coherence is mentioned as a possibility. Another comment about greening principle in the law is concerning access to justice. When the law was being negotiated, the Parliament had proposed included a specific article on access to justice. An Article 11, which is very interesting if you can read it on screen. This was interesting because this was an attempt to greenlight the classic categories of EU law. But this was not accepted, and only an Article 9 on public participation remained in the law. To conclude, simply, before our discussion, it is clearly that at macro and micro level, greening clearly refers to a number of elements in EU law. A dense body of secondary law with ambitious objectives, climate neutrality, and an old and solemn principle of integration or principle of coherence. But the ambivalence remains very strong and raises a simple question of whether EU law can truly be a law of ecological transition. Thank you for your attention.